The complex law for YouTube is difficult to explain. I'm here to try to simplify it for you. The lesson begins now. Hi, I'm Dean Rod Vera. Aside from being a law dean, I'm also an intellectual property lawyer in practice for the last 20 years. I've also been teaching intellectual property for the last 10. I have a master's degree in intellectual property law and technology from the University of San Francisco. Go Dons! I will try my best to explain copyright law for YouTubers and content creators. Here, I will try to use principles of US law and Philippine law and how it is used for copyright with regards to YouTube. At the end of this video, I will explain how gray-haired old men from record companies are out there looking and making content claims and copyright strikes against YouTube videos. The definition of copyright. Copyright is a complex word using the words copyright and right. Literally, it means right to the copies. It's not only a right, but I would consider it more of a privilege because it is a private law and it is the choice of the copyright owner to either make a content claim or a copyright strike, or as harsh as an infringement suit. It should not be treated the same way the advertising industry treats the word copyright. There are jobs out there called copywriter. That's not the same thing. It is also a privilege because copyright law allows a monopoly on one's work. Technically, a monopoly is such a harsh word in business. It's also a long game if you know how to play it. What is protected? Simply put, copyright law protects works, which are either literary or artistic. Works are ideas expressed in tangible mediums of expression, which are perceived by the appropriate senses. Imagine the idea of a young boy wearing glasses, orphaned when he was a baby, and asked or invited to go to a magic school where he experienced the worst of life. That idea was thought of by a struggling single mom on a train ride to London. She put that idea into books, which became into movies. That's an example of how copyright works. Used by content creator. You're watching this video because you are a content creator wanting to find out about copyright for YouTube, or maybe a student of mine trying to get a good grade in class. Either way, you know that content in YouTube is audio-visual in nature. So as content creators, you might use musical compositions, videos, movies, photos, or even advertising material. All these things are copyrighted material and may still have protection. So, just because it's in the internet and it's downloadable doesn't mean it's free to use. Always check before you embed it in your content. Legal definition. I have to get this out of the way. Maybe there's a lawyer there watching this video and is going to check whether I give the right definition to the word copyright. Here it is. Under US law, copyright protects original works of authorship fixed in tangible medium of expressions, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with an aid of a machine or device. Under Philippine law, copyright protection subsists in original works or literary or artistic works and are protected from the moment of creation, irrespective of their mode of expression and regardless of their content, quality, or purpose. So which means the worst movie that you've ever seen is copyrighted. Duration. How long is copyright protection? It's longer than you think. In the Philippines, it starts or ends 50 years after the death of the author. In the US, it's even longer. It's 75 years. You have to know when that 50 years or 75 years start. It's from the death of the author, not the death of the record company. Not all works have 50 years after the lifetime. For photos, it's 50 years after the first publication. In copyright law, there's a principle between material and object. Simply put, It means that you may own the object or the medium of expression wherein the work was expressed, but you don't own the work itself. How does that follow? For example, you may own a CD or a DVD, but you don't own the content or the material in those CDs or DVDs. For the CDs or any other music, whether it be MP3 format, you can play as loudly and as much as you want, as long as you are at home. The moment you play the music or that movie outside your circle of family and friends, it could be considered as a public performance or public exhibition and may be subject to infringement, or even in this case for YouTube, a content claim or a copyright strike. Embedding. So, you've just finished a rough cut of your video, you've edited out all the bad parts, you did your jump cuts, your zoom cuts. Now you want to put your music or your photos. So now you're scouring the internet for the appropriate photo for your idea. If you use a photo or a movie scene or even a video, put it in your own content, you know that what you put in is not yours. If you post your video with that embedded music or photos and it's in your channel, your viewers or your untrained and naive subscribers will think that that portion of work that you borrowed is yours and that you are the author. This is what you have to avoid. I know you want to be as funny and as creative and as you want to make a great video, but if you use somebody else's work or somebody else's song or movie, you might be subject to a copyright strike or a content claim. Just think, what if I used your video from YouTube with my music? It's the same thing. Sometimes you see in the description of videos, copyright infringement or infringement not intended. It doesn't work that way. Intent in copyright law is immaterial. Copyright law is a special law. It means that intent is not a defense in copyright infringement or copyright claims. It's because you used work not your own and placed it and make it appear that it is yours. You might also see this term called CTTO, or credit to the owner. Like that first phrase I told you, it doesn't work because intent is immaterial. The mere fact that you showed CTTO, you are admitting to using somebody else's work. That CTTO will only work if the owner of the work allows you to use his photo or his music, and all he asks is you credit him to be the author. Meaning, or what it means is that if you use CTTO, you will ask permission from the owner. Permission. Lawyers and authors would love to know that you've sought permission to use their work. It shows sincerity, honesty on your part. If you are a beginner YouTuber, the permission might even be for free. It'll be totally different if your channel or your account is monetized. It is because every video you put up there in your monetized channel, you're out there trying to make money. When you seek a license, you have to know 3 important parts. First, the license to sync the work in your video. Is it the whole work? Is it the portion of the work? Is it the major part of your video? Or is it just the background? All these things have to be disclosed to the owner when you seek permission or seek license. Number 2, the period or the term of the license. Is it 1 year? Is it 2 years? Is it 5 years? You have to note that because when the term is over, then the author can make a copyright claim or a copyright strike against your video because the term or the permission has ended. A fee. Sometimes when you borrow or have a license to use a work, you have to pay a fee. But in case it's free, you have to know the restrictions that the author or the owner will place on your the use of the content that you borrow. The length, the placement, even the nature of your content. You have to make it clear to the author or creator before you ask permission. Not all videos or music that you might want to use for your video is copyrighted. Some may be copyrighted but yet free to use. I'll explain 3 ways how that may be done. The first one I explained a while ago was permission to use. The second type of free to use is what they call license free. These are works that are still copyright protected, but the owner or the author has allowed its use in other mediums. Sometimes they ask for a CTTO, sometimes they might ask for a like in Facebook or a follow on Instagram. But take note that the owner still retains or reserves his rights for that material. The third one, which has a two-fold definition, it's called public domain. The first fold is that these are materials which never had copyright protection, meaning it's either that they when the work was created, the literary artistic work was created, there was no copyright law, or that the material has already passed its term. For example, those authors who have passed away in 1969 or earlier, they have gone beyond 50 years. Some of those works may be subject already to or part of the public domain. One thing about classical music, you might think songs written in the 1800s or the 1500s, they may be public domain, but that's not always the case. Although the music itself is free to use or part of the public domain, sometimes recorded versions will have the same algorithm where the YouTube bot would recognize it as such. As promised, I mentioned that I will explain why the gray-haired old men in these record companies are out there searching the YouTube videos to make copyright strikes and content claims. Well, it's basically the copyright protection that they want to enforce. Record companies or authors have, I said a while ago, that have put in blood, sweat, and tears to make the work, and they need to reap the benefits back. So, if you are a YouTuber or a content creator that want to put their work into your work, it's but right that you first have to ask permission. If you don't, to them and under the law and the eyes of the judge, that may be considered theft. It's because intellectual property is still property, and using it without permission is considered theft. In another video, I will explain what a content claim is or what a copyright strike is and what you can do about it. I hope I've explained copyright law for YouTubers as simply as I can. Just if you have any questions or any inquiries, feel free to post it in the comments and I'll get back to you as soon as I can. Again, I appreciate your time. Please do me a favor and click like and subscribe button and also the notification bell. It really helps this channel to grow. This is Dean Vera saying stay safe, and it's not what you know, it's what they don't know.